Good evening and very happy new year to all of our viewers. On the occasion of 106th birth anniversary of late legend Advocate Nani Palkiwala and constitutional luminary, we are organizing this corporate Maha Utsav. Today is our first day and our topic for the discussion is Company Law and SEBI Act. As we know, the company law is giving various provisions for incorporations and keep the transparency between the shareholders and the management and various audit procedures to have a fair corporate dealing. Apart from that, we have a SEBI Act which basically regulates all the shareholders who have their equity shares in the different companies. Today we have our guest, Advocate Jayaprakash Somani, advocate at the Supreme Court of India. He is having a more than 30 years of experience in a legal field. He has written more than 60 plus books on the different field of the legal, like civil, criminal, corporate. Apart from that, he is also an independent director and insolvency professionals. Over to you, sir.
Thank you. Thank you, Manoj. Friends, this corporate law Mahotsav on the occasion of 106th birth anniversary of my Guru Nani Palkiwala, who has given the doctrine of basic structure to our nation. And due to that doctrine, our constitution is intact and our independence is also intact. Democracy specifically is intact. So this is the corporate law Mahotsav. Last year also we have conducted a series of the webinars which is available on YouTube. And now this series will come to YouTube also and come to my app also in the form of course also. So let me start. Let me share this screen with you. Give me a few seconds. We will cover today's lecture in Hindi English, but we'll speak English more because this is related to law and we all have the habit of English in law, specifically in Supreme Court and High Court. We have to argue also in English. So it is better to speak in English, but somewhere if required, I will elaborate in Hindi also. Yes. First, I will take the company law. Study material you will not get on the YouTube, but study material you will get on our app in the form of course. So this is Corporate Law Mahotsav 2026. This is today's, yeah. First of all, I will give you the comprehensive information about Company Act 2013. Then I will show you the Company Act 2013's Bare Act also. Then we will switch our program towards SEBI. SEBI is company law is for corporate governance of corporate, and SEBI is related to the part of the stock exchange, shareholding, public initial public offer, that is IPO, then debentures, then preferential shares. So all type of shares control is of SEBI. So SEBI Act 1992 is there, and we'll see the comprehensive information about SEBI. Then I will show you the SEBI Act also. दोस्तों एक कंपनी एक्ट जो है ना, एक कंपनी एक्ट क्यों फॉर्म हुआ, कैसा हुआ, वो उसकी जरूरत क्यों पड़ी, I will give you information about this in short but in comprehensive manner. The Companies Act 2013 is a primary legislation governing the formation. इसमें क्या क्या कवर है? formation of company, functioning of company, regulation of company, dissolution of companies in India. It modernized and replaced the earlier Company Act 1956. जब मैं लॉ पढ़ा तब मुझे कंपनी एक्ट 1956 था, बिकॉज आई हैव कंप्लीटेड माय लॉ डिग्री इन 1987. So that time Company Act 1956 was into existence. But in 2013, new act replaced an earlier act repealed. So to align Indian company law with contemporary business practices, improve corporate governance, strengthened investor protection, corporate governance improve करना, इन्वेस्टर प्रोटेक्शन जो है उसको और स्ट्रेंथ करना, जो इन्वेस्ट करते हैं कंपनी में, शेयर होल्डर्स का हित जो है, दैट प्रोटेक्शन ऑफ इन्वेस्टर, वी शुड स्ट्रेंथन दैट, एंड फॉस्टर ईज ऑफ डूइंग बिजनेस, एंड ईज ऑफ डूइंग बिजनेस लाना, ताकि इजीली फॉरेन की कंपनियां भी हमारे यहाँ पे आए, हमारे यहाँ के भी जो उद्योजक है उनको कंपनी चलाना बहुत इजी हो जाए. इसलिए इजी going business should happen. This is the main motto behind this Company Act. So background and purpose. The act was enacted by the Parliament as Act number 18 of 2013 and received presidential assent on 29th August 2013. प्रेसिडेंट साहब ने उस समय 29 अगस्त को सिग्नेचर किया उसके ऊपर, दोनों पार्लियामेंट ने पास करने के बाद. Then it was brought into force in a phased manner with several key provisions commencing on different dates. The major portion coming into effect from 1st April 2014. So major portion will be notified on 1st April 2014. The Companies Act 2013 replaced the Companies Act 1956 with a modern statutory framework tailored to contemporary global business, focusing on accountability, transparency, growth and investors' rights. ये बहुत बड़ा law है. More than 450 sections are there. Near about 470 sections are there. So many rules are there. Chapters are 29. I will give you all the information. So what is the structure of this act? The act is a comprehensive, encompassing the entire life cycle of a company, from incorporation to winding up. Its structure is as follows. Total provisions, sections 470 sections originally in the act. Then subsections also inserted in that. Some sections are repealed from this act and inserted in another act also. I will show you the bare act also after finishing this comprehensive discussion. Schedules, 7 schedules are there. Unlike the 1956 Act, the Companies Act 2013 does not formally categorize provisions into parts. Instead, it is divided by chapters focusing on the thematic areas. So chapters and key areas covered. This is the most important thing for the chartered accountants as well as legal practitioners who are practicing in NCLT, NCALT, that is NCLAT in High Court and Supreme Court. Those who are practicing in corporate law, like our law firm. So we are practicing corporate law, also practicing property laws, we are practicing civil laws, we are practicing in army laws, we will practicing service matters, we will practicing criminal matters. So many sectors our law firm is covering. JSAS law firm is there. And these are the chapters. So first chapter is related to preliminary definitions, extent, applications. Second, incorporation of company and matter incidental thereto. Third, prospectus and allotment of securities. Fourth, share capital and debentures. Fifth, acceptance of deposits. Sixth, registration of charges. Seventh, management and administration. Eighth, declaration and payment of dividend. 9, accounts of companies. 10, audit and auditors. 11th, appointment and qualification of directors. 12, meetings of boards and powers. 13th, inspection, inquiry and investigation. 14th, compromises, arrangements and amalgamations. 15th, prevention of operation and mismanagement. 16th, revival and rehabilitation of companies. 17th, winding up. 18th, companies incorporated outside India. Then 19th, registered valuers. 20, NCLT and NCLAT. Then 21, special codes. 22, offenses and penalties. And 23, miscellaneous. This is a thematic outline. So now we will go towards silent feature of the Act. The 2013 Act introduced, I have written this blog, and very soon I will publish this blog also on my website, and I will share it on different social media like LinkedIn and Facebook like others. So one person company, OPC, an individual can incorporate a company by himself or herself. Corporate social responsibility, CSR, mandatory for certain classes of companies. Section is related 135. Independent directors and board of committees, stronger governance requirement. These are the silent features of Act. Class action suits, enabling shareholders and depositors to seek relief. Mandatory rotation of auditors, increased disclosures and norms, enhanced penalties, and more. Some important sections with practical significance. Let me tell you some important sections of this Company Act. ये बहुत जरूरी है क्योंकि लॉयर को पूरा की पूरा एक्ट हर बार पढ़ना पॉसिबल नहीं है, नाइदर सीए को नॉर कंपनी के जो ऑडिटर वगैरह रहते हैं उनको भी पॉसिबल नहीं है. बट इफ यू नो दी भाई ये सेक्शन से ये सेक्शन तक ये कवर होता है तो इट इज वेरी इजी टू हैंडल दैट एक्ट. So section 2, definition. This section defines important terminology, that is prospectus, articles, share, appeal, tribunal, etc. Section 4 to 7, it is related to incorporation. This deals with the memorandum and article of association and formation of a company. Section 73 to 76, acceptance of deposit. Regulate the way companies raise deposits from public and members with heavy compliances. इतना आसान नहीं है, और अभी तो सेबी ने बहुत स्ट्रॉन्ग कर दिया कि जब भी आप पब्लिक इशू निकालते हैं, that time if you are taking beyond limitation of that your limitation, you are taking the public issue premium, then insolvency professional will be appointed there to control that affairs of that public issue. So पब्लिक ने जो पैसा जिस काम के लिए दिया है वो काम के लिए ही यूज होना चाहिए. So that is most important thing. So acceptance of deposit have the heavy compliances. Section 180, power of boards. Board of director power, because company is an artificial legal person. No live person is that is artificial legal person, and company is acting, the board of director of company is acting on behalf of company. Authority of the board to undertake major transactions like borrowing, investments, etc., subject to shareholders' approval. Section 134, financial statements. Companies must prepare true and fair financial statements, including board report disclosures. Then Section 139, appointment of auditors. Prescribed audit appointment and rotation requirements. Section 149 is related to board composition. Introduces independent director and other board structure norms. I'm qualified independent director and I'm registered lifetime member on MCI's database portal. Ministry of Corporate Affairs, MCA's database portal. I'm lifetime registered member there. So near about 50% director should be independent director. But there is a certain limit, some turnover limit, some size limit is there. So everything is given in this particular sections. Board composition. Then section 241 to 242, operation and mismanagement. जितने भी केसेस बनते हैं एनसीएलटी में, एनसीएलटी के बाद एनक्लैट में आते हैं, बिकॉज कंपनी लॉ हैव द ट्रायल कोर्ट एनसीएलटी, नेशनल कंपनी लॉ ट्राइब्यूनल. ये सिविल कोर्ट में नहीं चलते हैं मैटर, ये एनसीएलटी में चलता है. तो एनसीएलटी के बाद अपील आता है एनक्लैट, एनसीएएलटी, नेशनल कंपनी लॉ एपेलेट ट्राइब्यूनल. और एपेलेट ट्राइब्यूनल के बाद आता है सुप्रीम कोर्ट में स्टैट्यूटरी अपील है सेक्शन 62 के अनुसार. इसका इंसॉल्वेंसी का है, इसका जो सेक्शन है, ये सेक्शन हम जब बेरेट में जाएंगे आई विल शो यू दैट. सो ऑपरेशन एंड मिसमैनेजमेंट provides remedies to shareholders where affairs are conducted prejudiciously. कुछ ऐसा गलत तरीके से कुछ अफेयर्स कंडक्ट करते हैं तो फिर उनको रेमेडीज शेयर होल्डर को है. सेक्शन 245 to 246 क्लास एक्शन enables collective lawsuits by shareholders and depositors. Section 423 appeals to Supreme Court, NCLT, NCLAT, etc. specifies appellate jurisdiction in certain company matters. Now I will try to show you some case laws related to the Companies Act. Leading Supreme Court case laws and judicial trends. Although many High Court and the newly constituted National Company Law Tribunal handle company law disputes, the Supreme Court's jurisprudence influences interpretation and reform. So पहला एक बहुत क्या बोलते हैं उसको फेमस केस है, टाटा सन्स वर्सेस साइरस मिस्ट्री, 2020 उनका एक केस है. A landmark corporate governance case involving allegation of operation and mismanagement under section 241 to 242 of the Act. The Supreme Court upheld the governance structure and management decisions of Tata Sons, clarifying that removal of director, even if harsh, must be viewed contextually with company's articles and laws. This judgment shaped the understanding of corporate hierarchy, fiduciary duties, and minority protection under company law. Then Shailja Krishna versus Satori Global Limited. The Supreme Court clarifies that NCLT has jurisdiction to entertain cases of fraud and mismanagement also. When fraud is integral to operation claim, reinforcing shareholder protection within corporate disputes. Directors disqualification, section 164(2) interpretation. In Union of India versus Jai Shankar Agrari The Supreme Court upheld that disqualification of directors for non-filing of financials should apply prospectively from the date of notification due to the penal nature of provision endorsing fairness in application. Judicial influence on the act's drafting also. The Satyam scandal, Satyam का बहुत फेमस केस है. Satyam scandal, corporate accounting fraud led directly to the governance provisions in the act, like mandatory independent directors, audit committees duties, and auditor rotation, section 139, 149, 176, 7, etc. And another one case is the Sahara case, SEBI versus Sahara, influenced tightening investors' protections and private placement norms, section 42 and 73. Direct Supreme Court cases expressly under Companies Act 2013 are increasing. Many corporate disputes also involve SEBI, tax, insolvency law, but influenced corporate law interpretation. तो सुप्रीम कोर्ट का काम ही है कि लॉ को इंटरप्रेट करके दें. इसलिए देर आर सो मेनी केस लॉज. आज हम कंपनीज एक्ट 2013 देख रहे हैं, लेकिन 1956 का अगर कंपनी लॉ का केस लॉ निकाले तो मोर देन सो मेनी केसेस आर देयर. And Company Law 1956 and Company Act 2013, majority of part is same, but restructuring in some sections and adding some corporate governors like that, independent director like that, then CSR, such type of new things are in 2013's Act. Enforcement and adjudication mechanisms. The Act set up by adjudicatory bodies, National Law Company Law Tribunal, that is NCLT, primary forum for company law disputes, restructuring, operation petitions, mergers, etc. National Company Law Appellate Tribunal, NCALT, hears appeals from the NCLT. स्पेशल कोर्ट फॉर स्पीडी ट्रायल ऑफ ऑफेंसेस अंडर द एक्ट. कभी कभी कुछ ऐसे स्कैंडल्स हो जाते हैं, सो फॉर दैट टाइम हाई कोर्ट इज कॉन्स्टिट्यूट अ स्पेशल कोर्ट. दैट पावर हैव टू ओनली हाई कोर्ट्स टू कॉन्स्टिट्यूट द स्पेशल कोर्ट टू फॉर स्पीडी ट्रायल ऑफ दैट ऑफेंसेस, बिकॉज NCLT and NCLAT are the quasi judiciary authority. So High Court is taking care of appointing the special courts when necessary. Supreme Court of India, apex appellate authority for substantial question of laws. You can find my books on like company law, then insolvency, then insider trader, some case laws. So many, मेरे ख्याल से more than 10 to 15 books are related to corporate governance, corporate law, different corporate law. Total more than 65 books are there, but from that 10 to 15 may be in corporate law. You can just go to our website also, you will find the link are there, jayprakashsomani.com, or you can visit to supremecourtlawfirm.com. You will find our books links there. And another way is to go to just Amazon and Flipkart and just type there Jayprakash Somani books. You can find the list of my books also, which all related to the Supreme Court case laws. Then corporate governance and investor protection. The major focus of 2013 Act is strengthening governance with provisions on independent directors, audit committees, related party transactions, CSR obligations, class auction suit, etc. Insider training disclosures in coordination with SEBI. These provisions are directors and managements more accountable, improve transparency and protect minority investors, align Indian law with global best practices. So I'm concluding with my remarks. The Companies Act 2013 is a landmark legislation that redefines the corporate legal framework in India. It seeks a balanced corporate freedom with accountability, strengthen investors' rights, modernized governance, and provides clear mechanism for dispute resolution. Its interpretation continues to evolve through judicial pronouncements, especially in corporate governance and shareholder protection. So this is the comprehensive information about Company Act. Now I will show you the Bear Act. It is not possible for us to go line by line to Bear Act. Just I want to show you that, and you will find all the study material in our course, my app, Jaiprakash Somani Supreme Court app. But after some days, not immediately. After 1 month, we will compile all this corporate law separate part there, and then we will notify you. Okay, by now this corporate law full Mahotsav is available there. So see the arrangement of sections. Chapter 1 preliminary, 2 sections are there. Chapter 2 incorporation of company and matters incidental thereto. So 3 section to 22 section. Then chapter 3 prospectus and allotment of securities. In that part 1 is public offer. Public offer section 23 to 41. Part 2 private placement 42 section. Chapter 4 share capital and debentures. The most important thing in public limited company specifically. Section 43 to 72. Then chapter 5 acceptance of deposit by companies. Section 73 to 76A. Chapter 6 registration of charges. Section 77 to 87. Chapter 7 management and administration. Section 88 to 122. Then chapter 8 declaration and payment of dividend. So payment of dividend, declaration of dividend sections, related sections are 123 to 127. Chapter 9 accounts of the companies. Section 128 to 138. Chapter 10 audit and auditors. Section 139 to 148. Chapter 11 appointment and qualification of directors. Section 149 to 172. Then chapter 7 meetings of board and its power. Section 173 to 195. Then chapter 13 appointment and remuneration of managerial personnel. Section 196 to 205. Chapter 14 inspection, inquiry and investigation. Section 206 to 229. Chapter 15 compromises, arrangements and amalgamations. Section 230 to 240. Chapter 16 prevention of operation and mismanagement. Section 241 to 246 registered valuers. This is chapter 17. 247. Chapter 18 removal of name of companies from the register of companies. Section 248 to 252. Chapter 19 revival and rehabilitation of 6 companies. So these sections are omitted from here. 253 to 269, and they come into insolvency also, and in a SIC unit act is also there. Winding up, section 270, winding up by tribunal. Part 1, winding up by the tribunal. Section 271 to 303. Then 304 to 323 omitted because some part go into insolvency code. Insolvency, bankruptcy. We will cover in this महोत्सव. इसमें लेने वाले हैं हम इंसॉल्वेंसी का सब लेने वाला है. CIRP प्रोसेस वगैरह सब लेने वाले. लिक्विडेशन प्रोसेस, आई विल कवर दैट. Then part 3, provisions applicable to every mode of winding up. Section 324 to 358. Then part 4, official liquidator. Section 359 to 365. So insolvency के थ्रू जो लिक्विडेशन होता है वो थोड़ा अलग है. ओके, दैट इज एज पर द इंसॉल्वेंसी बैंक्रप्सी कोड. और कंपनी लॉ में जो इंसॉल्वेंसी का पोजीशन या लिक्विडेशन का प्रोसेस दिया है वो थोड़ा सा अलग है जो पार्ट 4 में दिया है. ओके, सो चैप्टर 21 Part 1, companies authorized to register under this Act, 366 to 374. In this chapter 21, Part 2 is winding up of unregistered companies, Section 375 to 378. Chapter 21A, producer companies. Part 1, preliminary. This is a new part incorporated. Preliminary, section 378A, definition. Part 2, incorporation of producer companies and other matters, 378B to 378N. Part 3, management of producer company, 378O to 378Z. Part 4, general meetings, 378ZA. Part 5, share capital and members' right. This is related to producer companies. Section 378ZB to 378ZD. Part 6, finance, accounts and audit, 378ZE to 378ZG. Part 6, loans to members and investments, 378ZK to 378ZL. Then Part 8, penalties, 378ZM. Part 9, amalgamation, mergers or division, 378ZN. Amalgamation, mergers, division, etc. to form new producer companies. We will take separate one seminar on producer companies also separately. Resolution of dispute, Part 10, Section 378ZO. Part 11, miscellaneous provisions, 378ZP to 378ZR. Part 12, reconversion of producer company to interstate cooperative society, 378ZS to 378ZU. Then chapter 22, कंपनीज इनकॉर्पोरेट आउटसाइड इंडिया, जो बाहर रजिस्टर हुई है भारत के बाहर, वो कंपनी जब भारत में काम करेगी तो उनके लिए क्या रूल्स रेगुलेशंस हो गए. कंपनीज इनकॉर्पोरेट आउटसाइड इंडिया, 379 सेक्शन टू 393 सेक्शन. देन चैप्टर 23 government companies, 394, 395. Chapter 24, registration offices and fees, section 396 to 404. Chapter 25, companies to furnish information or statistics, section 405. Chapter 26, nidhis. This is related to section 406. Chapter 27, National Company Law Tribunal and Appellate Tribunal, section 407 to section 334. Then chapter 28, Special Courts, section 435 to 446b. And last chapter 29, Miscellaneous. It contains section 447 to 470. तो 470 और 378 सेक्शन में कितने सेक्शन दिए थे विच इज रिलेटेड टू प्रोड्यूसर कंपनीज? वो अगर आउट करते तो मोर देन 500 सेक्शन जाएंगे इसके, सब सेक्शन पकड़ के. एंड शेड्यूल्स दिए हैं, 7 शेड्यूल्स है इसमें, और नीचे पूरा की पूरा ये बेयर एक्ट है. आराम से जा सकते हैं. 370 पेज का बेयर एक्ट है. ये सब कुछ आपको ऐप पे मिलेगा, सब स्टडी मटेरियल ऐप पे मिलेगा विद दिस रिकॉर्डेड वीडियो. कुछ दिन के बाद, आफ्टर 1 मंथ, जैसे हम ऐप पे डालेंगे विल नोटिफाई यू. देन नाउ सेबी. व्हाई सेबी एक्ट इज रिक्वायर्ड? हर्षद मेहता का जो स्कैम हुआ था ना शेयर का ऊपर, उसके बाद ये सेबी की जरूरत पड़ी और सेबी एक्टिवेट हुआ, गवर्नमेंट ने उसको लाया. तो द सेबी एक्ट 1992, कॉम्प्रिहेंसिव ब्लॉक, ये मेरा नाम वगैरह यहाँ पे ब्लॉक पे है. द सिक्योरिटीज एंड एक्सचेंज बोर्ड ऑफ इंडिया एक्ट, सेबी का मतलब सिक्योरिटीज एंड एक्सचेंज बोर्ड ऑफ इंडिया एक्ट 1992. This is Act number 15 of 1992. Is the primary statute that provides the statutory basis for SEBI. India's securities market regulator. The Act empowered SEBI to protect investor interests, promote securities market development, and regulate market intermediaries and practices. It was enacted on 4th April 1992 and came into force on 13th January 1992. Purpose and background of this act. Before 1992, SEBI existed as a non-statutory body established by a government resolution in 1988 with limited power. बहुत कम पावर थे सेबी के पास. 1988 में वो आए थे, बट नॉट स्टैट्यूटरी बॉडी थी. The act was introduced in Parliament after major market scandals, notably the Harshad Mehta scam, to give SEBI statutory powers to effectively regulate capital markets and safeguard investors. Structure of this act. ये एक्ट का स्ट्रक्चर है. चैप्टर 10 है, सेक्शंस 91 है. दिखते समय आपको थोड़े कम दिखेंगे बेयर एक्ट में, बट व्हेन यू कैलकुलेट दी सब सेक्शंस ना, देन इट कम्स अराउंड 91. हियर an overview of how the act is organized. So chapter wise outline. Chapter 1 preliminary. इसमें सेक्शन 1 है शॉर्ट टाइटल, एक्सटेंट एंड कमेंसमेंट. डेफिनेशन सेक्शन 2 में आएंगे. चैप्टर 2 एस्टेब्लिशमेंट ऑफ सेबी. सेबी कॉन्स्टिट्यूटेड एज अ कॉर्पोरेट बॉडी, ए सेक्शन 3 है. मैनेजमेंट, रिमूवल ऑफ मेंबर्स एंड टर्म and meetings, section 4 to 9. So when you are running the public limited company, that time you have to do the collaboration, comprehensive study of company law as well as SEBI laws. Chapter 3, transfer of assets. Transfer of assets and liabilities from old board to statutory SEBI. पुराना जो बोर्ड था ना 1988 का, उसका पूरा के पूरा एसेट ट्रांसफर नए बोर्ड को करना, ये इसके लिए दिस इज नॉट रिलेटेड टू जनरल पब्लिक, दिस इज रिलेटेड टू इंटरनल पार्ट. Chapter 4, power and functions of SEBI. The duties to protect investors and regulate markets, section 11 में दिया है. Power to regulate prospectus, offer, documents, etc. ये section 11A में दिया है. Recognizing collective investment schemes, section 11AA. Power to issue directions and penalties, section 11B. Investigation, section 11C, and seize and desist proceedings, section 11D. So section 11 is very important in the eyes of the advocate, because when litigations arises, so chartered accountant or advocate can appear in NCLT. In NCLAT also, chartered accountant can appear, a company secretary can appear. But in High Court and Supreme Court, there should be only advocate. High Court and Supreme Court. High Court have very less jurisdiction, only writ petition jurisdiction is there under Article 226 and 227, and some winding up jurisdiction is there. Chapter 5, registration certificate. Registration for broker, sub-broker, and other intermediary. This is section 12. Chapter 5A, prohibition of manipulative and deceptive devices, insider trading, etc. This is prohibition is. So this is given in section 12A, prohibits insider trading, fraud, and substantial acquisition without compliance. Then chapter 6, finance, accounts, and audit. SEBI's funds, audit, accounts, etc. Chapter 6A, penalties and adjudication. Penalties for contraventions and adjudication procedures. Chapter 6B, securities appellate tribunal. Establishment authority of procedures for SAT. SAT means Security Appellate Tribunal. So SEBI board is giving some board itself is doing some adjudication, and against the order of board, SEBI, against the SEBI order, then appellate tribunal, that is SAT, Securities Appellate Tribunal is there. And after this SAT, matter come to NCLAT. And after NCLAT, it comes to the Supreme Court. So chapter 7, miscellaneous, general provision on rulemaking, appeals, offenses, and more. I will show you some, when I will show you the bare act, I will show you the appellate provision like that. Key objectives of the SEBI Act. The Act core purposes found in section 11 can be summarized as protect interest of investor in securities, promote development of a fair, efficient, and transparent securities market, regulate the securities market, and control malpractices. The tri-parties mandate balances investor protection with industry development and avoiding over-regulations. Important provisions and sections. Section 3, establishment of SEBI. SEBI is established as a corporate body with perpetual succession and common seal. Section 4, management, defines board composition, including chairman, members from Ministry of Finance, RBI, nominee, and whole-time members. जैसा आईबीबीआई बोर्ड एस्टैब्लिश हुआ, सेबी तो काफी पहले हुआ एस्टैब्लिश 1992 में। आईबीबीआई अभी हुआ 2016 में। सो वेरी पावरफुल बोर्ड नाउ। In section 11A and 11AA, regulation of public issues and identification of collective investment schemes. Section 11B powers 11B empowers SEBI to issue directions and levy penalties. डायरेक्शन इशू करने का और पेनल्टीज लगाने का उनको पावर 11B देता है। सेक्शन 11C एंड डी इन्वेस्टिगेशन power and seize and desist proceedings to stop unfair practices. Section 12, registration requirement for market intermediaries, brokers, transfer agents, etc. Section 12A, prohibit insider trading and market manipulations and regulates tax overs. And Chapter 6A and 6B contain penalties, adjudication processes and appellate remedies. ये सब ये लास्ट चैप्टर में दिए। Then interaction with other laws. Along with the SEBI Act is a stand-alone regulator scheme. SEBI also works in tandem with Securities Contract Regulation Act 1956, Companies Act, that is a section on public issue and transfers, and Depositories Act 1996. The broad framework ensures multi-layer compliance for listing entities and intermediaries. Important Supreme Court case laws under SEBI Act. ये बताना जरूरी है बिकॉज एज अ प्रैक्टिसिंग लॉयर इन सुप्रीम कोर्ट ऑफ इंडिया, जब तक मैं केस लॉज नहीं बताऊंगा तब तक मुझे अच्छा नहीं लगेगा. सो आई विल एलेबरेट यू सम केस लॉज रिलेटेड टू SEBI Act. Although many SEBI matters are first dealt with by SAT or NCLT, the Supreme Court has delivered several key judgments shaping SEBI's power and securities regulation. So one case is SEBI versus Sahara India Real Estate Corporation and others, a landmark security law case where the Supreme Court examined SEBI's authority over the public issues and investor protection. The apex court directed Sahara Group companies to refund huge sum collected from the investor through optional fully convertible debentures, OFCDs. Optionally fully convertible debentures for violating SEBI norms and capital market rules, reinforcing SEBI's jurisdiction and power under the Act and related regulations. So this is the greatness of our apex court. Apex court always strengthening the statutory bodies. सो सेबी को मजबूत करने का काम सुप्रीम कोर्ट के एक एक जजमेंट ने बहुत अच्छा किया है, बिकॉज दे हैव इंटरप्रेटेड द particular statute of that SEBI Act in well manner, so that practically application of that particular statute, Supreme Court has elaborated in that judgment. Then second, SEBI versus Ram Kishori Gupta and others, a 2025 का latest judgment है. The Supreme Court held that the doctrine of res judicata and constructive res judicata applies to quasi-judicial proceedings before SEBI, affirming that SEBI cannot issue multiple orders on the same cause of action when a final order is already in force. This strengthened procedural fairness in SEBI's enforcement action. सो ये डॉक्ट्रिन ऑफ रे जुडिकेटा जो है ना, जो सीपीसी में सेक्शन 11 में दिया हुआ है, तो इसकी ये दिस इज आल्सो एप्लीकेबल इन सेबी और other quasi judicial forum like NCLT like that, वहां पे भी applicable है. Once that matter is adjudicated properly, the same type of matter cannot be raised again. So this landmark judgment, SEBI versus Ram Kishori Gupta. Now, SEBI versus Pan Asia Advisors Limited and others. The Supreme Court upheld SEBI's regulatory authority in reinforcing insider trading norms, affirming the validity and enforcement of SEBI regulations against market abuse. Then SEBI versus Price Waterhouse Coopers. The involving corporate governance, the apex court upheld SEBI's power to impose penalties and restriction and auditors for violation of securities law, emphasizing enforcement against professional intermediaries. Then SEBI versus Rakhi Trading Private Limited, the Supreme Court reiterated SEBI's authority. Reiterated का मतलब होता है again explain करना. Explaining again reiterating. बार बार बोलना, बार बार कहना, that is reiterating. Supreme Court reiterated SEBI's authority over fraudulent and unfair trade practices, reinforcing the regulator's role in maintaining market integrity. Role of the Security Appellate Tribunal. अभी SAT का रोल शॉर्ट में बता रहा हूं आपको. The Act provides for the Securities Appellate Tribunal SAT under Chapter 6B to hear the appeal against the SEBI order. SEBI जो ऑर्डर करेगा उसके अगेंस्ट SAT में जाएगा. And SAT's decision can further be appealed to Supreme Court on substantial point of law. Substantial question of law अगर है तो SAT का डायरेक्ट डिसीजन सुप्रीम कोर्ट में जाएगा. बराबर है. तो एनक्लैट को यहां पे कट मार दिया है. लेकिन एनसीएलटी से अब एनक्लैट में जा सकता है, इवन दो दैट इज अ शेयर ट्रेडिंग मैटर. अगेंस्ट एनसीएलटी यू कैन गो टू एनक्लैट एंड एनक्लैट टू द सुप्रीम कोर्ट. बट व्हेन यू आर अप्रोच टू SAT after SEBI, when you are approached to SAT, then SAT, when question of laws, substantial question of laws are there, then directly SAT to Supreme Court is there. Importance of SEBI Act today. What is the importance in today's scenario? The SEBI Act strengthened by subsequent amendment and judicial scrutiny remains the central to Indian security regulations. It ensures investor protection, fair, transparent security markets, regulation of intermediaries and listed entities, mechanisms for enforcement and redress. The judiciary's interpretation continue to refine SEBI's power and procedural fairness in enforcement. So already we have seen that case, SEBI versus Ram Kishori Gupta, Sahara case, that is. And this is my concluding remark. The SEBI Act 1992 is a foundational to the regulation and development of financial markets in India. With a well-defined structure, robust powers, and backed by the judicial interpretation, it empowers SEBI to act decisively against unfair practices and protect investors while promoting orderly market developments. So this is the comprehensive information about SEBI with case laws, everything I have elaborated. Then I will show you the bare act of SEBI, Security and Exchange Board of India Act 1992. Last updated 29/2021. Chapter 1, preliminary. Two sections are there. Chapter 2 is related to establishment of Securities and Exchange Board of India. So section 3 to 9. Chapter 3 is related to transfer of asset, liability, etc. to the existing security and exchange board to the board. ये सेक्शन 10 है. जनरल लॉयर हमारे लॉयर्स के लिए या कॉर्पोरेट मेंबर्स के लिए नहीं, कॉर्पोरेट्स के लिए, कंपनीज के लिए ये चैप्टर जो 4 है, दैट इज मोस्ट इंपॉर्टेंट, पावर एंड फंक्शंस ऑफ द बोर्ड. सो सेक्शन 11 to 11D. Chapter 5, registration certificate. Section 12, registration of stock broker, sub broker, share transfer agent, etc. is covered in this chapter. Then chapter 5A, prohibition of manipulative and deceptive devices, insider trading, and substantial acquisition of securities or control. I think I have separate video on insider trading like that. Just search out on YouTube. You will find my more than 500 videos now on different Supreme Court case laws or different laws, or some videos are related to export import also, because I'm MBA in international trade and LLB. So my previously I have taken near about 10 years continuous rigorous every Saturday Sunday workshop all over India, Bangalore, Hyderabad, and all courses of mine are available on my app of export import. Once a person will attend that course, this is already recorded courses and lifetime access is there, and a very reasonable amount. Not reasonable, it is much below than reasonable. But when you implement that knowledge, that very practical knowledge, export import management, all, and there are small courses, so you can buy what you want. Then chapter 5A, prohibition of manipulative and deceptive devices, insider trading, and substantial acquisition and securities or control. 12A, prohibition of manipulative, everything is given there. Then chapter 6, finance, accounts and audit. Section 13 to 15. Chapter 6A, penalties and adjudication. This is the most important chapter as per concerned legal practice in NCLT and CLAT, High Court and Supreme Court. Section 15A to section 15JB. For instance, penalties for failure to furnish information, return, etc. कुछ भी गड़बड़ किया तो क्या पेनल्टीज हैं? कुछ पेनल्टीज तो कंपनी को करोड़ों में. Then chapter 6B, establishment, jurisdiction, authorities and procedure of appellate tribunal. तो सैट का जो appellate tribunal है, सिक्योरिटी appellate tribunal, उसकी प्रोविजन सब यहाँ पे 15th K से 15th Z तक दिए हैं. तो खाली 15th सेक्शन में ही कितने सेक्शन देखो, ऊपर भी काफी है, नीचे भी काफी है. Then chapter 7, miscellaneous, from section 16 to section 35, और scheduled repeal किया है. This is the detail law. Meetings, offers, employed. Let me stop the sharing screen. Now friends, this is our first day of corporate law Mahotsav. We have initiated through Company Act and SEBI. And in next part, we will see what is given in that flyer. So same part we'll see on that particular day. Just motivate so many members to become a life member of नानी पालकीवाला नेशनल लॉ क्लब. हमारा लाइफ मेंबरशिप खाली 500 रुपए में है 20 साल के लिए. तो अच्छे अच्छे प्रोग्राम फ्री ऑफ कॉस्ट है. कुछ कुछ कोर्सेस हम पेड भी लेंगे तो उसमें डिस्काउंट रहता है, 50% तक डिस्काउंट है. अभी ये प्रोग्राम का देखिए ना, ये प्रोग्राम का अगर पूरा सीरीज का लेता है कोई तो 2000 टिकट है, एक वन सेशन का 500 है, बट फॉर लाइफ मेंबर इट इज फ्री ऑफ कॉस्ट. सो टू बिकम लाइफ मेंबर ऑफ नानी पालकीवाला नेशनल क्लब will give you the immense pleasure and immense value addition in your legal field. ओके, ये जरूरी नहीं है कि खाली लॉयर ने इसका लाइफ मेंबरशिप लेना. एनी पर्सन कैन गेट. लॉ अबाइडिंग सिटीजन, कॉर्पोरेट्स और कॉर्पोरेट ऑफिसर्स 500 रुपए तो जेब से भी डाल सकते हैं यार. उसके लिए आपको आपकी कंपनी ने 500 रुपए सैंक्शन करने की जरूरत नहीं है. जेब से भी डाल के लाइफ मेंबरशिप ले लो. जीवन भर आपके हमारे अलग अलग प्रोग्राम एंजॉय करो. नाउ Manoj will conclude this program. Manoj, now you can unmute yourself.
Thank you very much, sir, for such an enlightenment of company law and the SEBI Act. And it was in-depth knowledge that how the 2013 Corporate Act has changed, and it has came to fill the gap of the Satyam scandal by putting a audit in a scanning of a audit committee and rotation of the audit team, so that the continuous of 20-25 years same company was doing the audit has been demolished. Apart from that, we have gone with a SEBI Act where you have given a good difference that how IBC is basically protecting the rights of the creditors, and SEBI is protecting the rights of the shareholders. And we have gone through the different case laws which has been handled by the Supreme Court, like Sahara India and Satyam Computers. Thank you very much. Thanks to all the viewers for their time. Our next second day program is on 5th of the January, which will cover the RD BFI Act and SARFAESI Act, which is basically related to the debt and security and asset management. Thank you very much. Thank you, sir.
Thank you. Bye.